19th century, people have been nattering on about the British Constitution, and nobody can find it written down anywhere. But that's the sort of peculiar people we are, the British. We don't need to write everything down. We've got it imprinted on our minds and our hearts. Other countries, however, have their own ideas of constitution, which some of them are now trying to impose upon us. So many things have been said and written about the Constitution in the last year that one needs an interpretation by an expert. And today we've brought you an expert, and John will tell you his version of the whole Constitution fable and put it to rights for you in the way you never will have to worry anymore. For his clarity will solve all the problems. I give you John.
So I'm just looking at this from, really I've been involved with engineering and other things in my life, and came to the rule of law as a point of interest really. I started researching the matter in about 1999, just soon after the ban on pistol shooting. Because I used to make bullets for target pistol shooters, and my customers were all taken away from me, and the machinery that I developed to do it was computerized controlled machine of my own development. I got no compensation and so on, so I was put out of business really by the government without compensation for that side of it. And we wrote to the Parliament at the day and said, is it really right that Parliament can do just anything? Is that true? And back came the reply that Parliament is sovereign and they can do what it likes. And that set me off on the quest to discover what was the Constitution of the UK really was. On the way through I wrote things up, and I got to meet a leading QC, Leon Price, and the late Norris McWhirter, who thought that I'd laid the Constitution, the fundamentals most clear. And one way or another, it's been quite a learning curve. Anyway, really what we've got to consider is that have we got a written Constitution? And obviously we're often told that we haven't, but we've got lots of constitutional documents written over many centuries. All those who hold any office are contracted to obey it by their oaths of office and by the rules of law. So that's a fairly straightforward logical assumption that must apply if one is to have a rule of law. And therefore the question arises really, has Parliament been accorded absolute power? If so, there could be no constitutional limitations to control it. Conversely, if there is constitutional limitation, then it's plain that it ought to act as a firm limitation or boundary, at least until such time as it's changed or altered, and therefore there must necessarily be legal constraint and remedy for the people should it become abused. Well, one of the most famous documents of all time, of course, is the Magna Carta. And there's a copy at Salisbury Cathedral, not far from here. I expect many of you will have seen that. And of course this was a charter which King John was forced to sign. The intention was to constrain and limit his power, and that was indeed the purpose of it. And it's been reconfirmed throughout our history, I think some 32 or 33 times at one stage or another. If you wind forward to the next really most important occasion was the Glorious Revolution in 1688, when Magna Carta had fallen into disuse because of the divine right of the Stuart kings, and once again we had an upheaval. There was a revolution which was relatively peaceful, but it was forceful enough to throw James II out, and the settlement terms were made, and a declaration of rights was part of the settlement, and the crown was then handed over to William and Mary, which were the founders that moved through to the Protestant line of the Hanoverian succession. The document on the right hand side there is actually in the House of Lords Records Office. That is actually the Declaration of Rights which I'm holding, and that is the original document which was read to William and Mary before they were handed the crown in 1688 as the terms and conditions upon which they could hold the crown and to which they agreed. It was subsequently included with the Bill of Rights, which is the left-hand document there, and once they had re-established the throne in their name, and that was considered to be a lawful parliament, it was decided that people would attempt to try and subvert this again, and therefore a Bill of Rights should be made. And if you read the Bill of Rights, it is a bill which says, historically it opens with a little paragraph, said that James had done lots of things wrong. There was a settlement made which came in the form of a declaration, and here it is. And just after the very first top part of that paragraph up there on the Bill of Rights, the first sort of 6 inches, you'll find from there down it's the Declaration of Rights, because it cites it and says that's how it is, and we're going to confirm it and establish it with the force of law. So that is the fundamentals between the Declaration and the Bill of Rights. The whole point about Magna Carta was that there was a presumption for liberty to be imposed upon the governing authority, and therefore there was limitation of power. The right of enforcement against those that transgressed was not to be trial by diktat from autocratic authority, but by one's peers. And that, of course, is absolutely vital. Now, people often talk about Magna Carta and say, well, has it been repealed, and is it in statute law, is it current, and so on? Well, it was confirmed in statute law, and a lot of it has been repealed. However, the bit that they can't repeal is the clause which relates to trial by your peers. So that is still within the statute law book. And of course there was, if you've got a charter that's going to be constitutional, it did the other things. It created a right of redress and a right of enforcement, and said that yes, we can take up arms against the Crown under certain circumstances if there has been total and well-founded abuse. And once redress and remedy have been recovered, then the time allegiance will then once again be returned to the Crown. So it had teeth. There's its statutory version. That one was updated in 1979. If you go to the stationery office, you can order a copy of that. No free man shall be taken or imprisoned or disseized of his freehold or liberties or free custom, or be outlawed or be exiled or anywise destroyed. Nor will we not pass upon him, nor but by the lawful judgment of his peers or by the law of the land. We will sell to no man, we will not deny or defer justice or right. And elsewhere it says, shall not be infringed or broken, it shall be of no force or effect. So you can see it was intended to be a limiting document. This painting was actually done in the middle of the 1750s, but when William and Mary took to the throne, or got the crown at the end of the Glorious Revolution, as a settlement of the Glorious Revolution, they were offered the crown, as I've explained, with the Declaration of Rights, and this painting was actually done to celebrate that as a subsequent thing. But there you can see the speaker with the Declaration of Rights, which was read to William and Mary, who were sitting on the throne. And there's Lord Halifax with the crown waiting to present it to them. So much was thought of the great thing, and this was in the banqueting hall in Whitehall, of course. So the Revolution of 1688 was actually a victory for the supremacy of the law and the separation of power. This is the most vital, important bit that people don't really seem to quite understand, in my view. I believe that the supremacy was put into the law. After all, the divine right of kings was at a time at which the crown had, in effect, total power of governance. And the king was made to abide by the rule of law. So it was the constraint of the law upon the crown, which was the important point. And it wasn't a transfer of power to Parliament, which is what it's taken to be by our political parties today. There was no transfer of power at all. It was only that the Crown should hold the rightful and limited power. And so the power was limited by a contract between the people and the monarch to reaffirm the superiority of the rule of law. It was not a victory for Parliament over the Crown and the monarch, as it is frequently and usually portrayed. To prove this point about the transfer of power, as I've explained, the Stuart kings, under their divine right, had, of course, really total power. And there was no dispute as to where the power resided. And look what this says in the Bill of Rights. As I explained, it cites the Declaration in its text, and then it has a long paragraph at the end giving a history lesson really to explain what happened. And here it is: "And to whose princely persons the royal state, crown and dignity of the said realms, with all honours, styles, titles, regalities, prerogatives, powers, jurisdictions and authorities to the same belonging and appertaining, are most fully, rightfully and entirely invested and incorporated, united and annexed." So there you can see all the power that the Crown had rightfully prior to the Revolution, it had after it, at a time when there was no real power of any nature within the Commons and the Lords in terms of governing power. The way things were changed, so this is probably the most important document of all, because once William and Mary had come to the throne, it was decided that we should have a coronation oath, and that they needed to make sure that there had always been a coronation oath, but what wasn't in the Stuart King's coronation oath were the words in red, statutes in Parliament agreed on. And so they passed an act in April, and then April 1689, and then William and Mary were indeed crowned at their coronation and swore this oath. And the red words, as I explained, weren't in the old oath. And so this changed everything, because the Archbishop or Bishop shall say, "Will you solemnly promise and swear to govern the people of this Kingdom of England and the dominions thereto belonging, according to the statutes in Parliament agreed on, and the laws and customs of the same?" Now that is a vital ingredient, because once those words were in the coronation oath, it was then obvious that no crown or monarch could deny that they were bound by the statute law, because there it was in plain words. And so it was those words on that parchment, and I have to say it's a great thing to be able to go to our House of Lords Records Office and actually get out the original documents from that time, most beautifully written, as you can see, all stitched onto vellum, onto skin, stitched together. It's an incredible thing that we have these records in this way. A constitutionally limited monarchy, therefore, bound by the custom, law and statute, that was part of the oath. Clearly the prerogative power, therefore, may not be used in repugnance to the law in force. Because if the monarchs agreed to abide by the law in force, how can the power of prerogative power of the Crown, is just the monarch's ability to enforce things, go contrary to the law? It obviously can't. Therefore, a limitation of prerogative surely must be that it cannot be used in repugnance to the law. Royal assent is a prerogative of the Crown and a constitutional restraint of the law and custom. Well, it must be, mustn't it? For instance, our Declaration of Rights says that there shall be no torture, no cruel and unusual punishments, there shall be no taxation without representation, there shall be no standing armies, and many other things. And of course, freedom of speech in Parliament, which has recently hit the headlines with our friend the Speaker, and so on. Anyway, that is all part of the Bill of Rights, and those are constraints upon the Crown. And there, of course, are the words that make it utterly clear from the coronation oath. There is Queen Elizabeth's oath on the right-hand side, and her father's on the left. And because I'm a layman, of course, I wanted to check on all these things, so I've looked through many law books and references and so on, and it's not me dreaming it up. Here it is, Sir William Blackstone, one of our greatest lawyers. However, in what form it soever be conceived, this is most indisputably a fundamental and original express contract, and to reduce that contract to a plain certainty, so that whatever doubts might be formerly raised by weak and scrupulous minds about the existence of such an original contract, they must now entirely cease, especially with regard to every prince that has reigned since the year 1688. Well, this was 1765 when he wrote his famous commentaries on the laws of England, one of our great judges. So there it is utterly plain that we have a contractual situation regarding the coronation oath and so on. So I thought, well, this is very interesting, and having started this quest, I decided to get my MP to ask the then Prime Minister Tony Blair a parliamentary question, could a minister of the Crown recommend a breach of the coronation oath? They, after all, are supposed to abide by true allegiance and so on, and the rule of law. So kindly my MP at that time, Howard Flight, said, yes, that's a good question. I will send a written question to the Prime Minister. And the Prime Minister found it too difficult to answer. So he delegated it with a letter on the left via Jan Taylor to the then Home Secretary, Jack Straw, who replied on the right-hand side. And there's a bit of delegation on the left-hand side. And on the right, you can see the coronation oath. I'm replying in light of my constitutional responsibilities. I can confirm that the coronation oath is a solemn undertaking by the Sovereign and is regarded as binding throughout her reign. Her Majesty would not be advised to give her assent to a provision which contradicted that oath. Well, there you have it, ladies and gentlemen. I was very pleased to get that answer. I thought it was the right answer. It's a logical answer. It's the answer that I should get. Why it couldn't have come from the Prime Minister is quite beyond me. It was a perfectly simple question and shouldn't, of course, need asking. But there it is. So we had a plain answer. The next thing to do, really, was to look at the Coronation Oath Act again and here's the beginning of it. And it's very interesting because the preamble of the Coronation Oath Act tells you why the Coronation Oath was taken. Whereas by the laws and ancient usages of this realm, the kings and queens thereof have taken a solemn oath upon the evangelists at their respective coronations to maintain the statute, laws and customs of the said realm, and all the people and inhabitants thereof, in their spiritual and civil rights and properties. So there you are, there you have it. Those are the purposes of our government. And you can see that by maintaining the subject in their spiritual and civil rights and properties, you are maintaining the liberty of the subject and the people. So it gives and defines a purpose for governance. And the second promise of the Coronation Oath, very important. Will it your power cause law and justice and mercy to be executed in all your judgments? King or Queen, I will. And then, of course, the final sign-off at the time, the things which I have here before promised, I will perform and keep, so help me God. The King and Queen shall then kiss the book, and they're at that point presented with a large Bible. One of my friends, who's been involved with this for a long time, spotted this on eBay and kindly bought it for me for £7. And it's an original line print from the middle of the 1700s, and it depicts, as you can see, the Declaration of Rights being read to William and Mary. And it was for the Earl of Huntingdon. And if you look at the text at the top, it says, the Clerk of the Crown reading the Bill of Rights, of course it was really the Declaration, to the Prince and Princess of Orange in the banqueting house at Whitehall, previous to the offering of the crown. So there you have it, previous to the offering of the crown. There's no doubt about what happened, and it was celebrated subsequently very much. And of course, 300 years later, we had a shindig in our House of Commons and in Westminster Hall, Westminster, and the Queen, many heads of the Commonwealth states and so on, the Queen was asked to make a speech, and in it she said, experience has taught that peoples can enjoy the full fruits of liberty, security and justice only when they are represented in a sovereign legislature whose laws are interpreted by an independent judiciary. The Bill of Rights and the Scottish Claim of Rights of 1689, still part of the statute law, are the sure foundation on which the whole edifice of parliamentary democracy rests and had great influence abroad, especially in the United States of America and in the Commonwealth. Well, that's very interesting, isn't it? It's the sure foundation. Well, that's again incredibly useful for us. And we subsequently had struck a £2 coin to commemorate it, and there it is. And there was the Scottish Claim of Rights. The Scottish had an independent claim of rights at the same time. Sorry, that's the Bill of Rights, and then there's a Scottish Claim of Rights there, which was their silver coin. And interestingly, here is the other side of that first little presentation from the Mint. And if you look at the top left there, you can see a document with an ink splodge on. And also it's interesting that in here, of course, in this text, the declaration was principally an assertion of the rights of Parliament in its relations with the Crown, and effectively confirmed a shift in the balance of power from the Crown to Parliament. Well, I don't think that's really quite an accurate description. There wasn't really a shift of power. What the Crown couldn't do was to deny the law. And the principle is that the Commons and the Lords advise the Crown on its use of power. And the Crown would not generally go against that advice, but quid pro quo, that advice must also be for the purposes of the Constitution. That is quite plain. Anyway, it's interesting. There is the ink splodge document on the top left, as you saw, and that was actually a draft of the Declaration of Rights on the right-hand side there, on which the clerk spilt the ink. So it's quite an amazing thing. They still even have a draft handwritten part of it. But it's surprising, isn't it, that in the Mint's document they don't actually put, we've got the whole document exists, and they didn't actually put a picture of that. They just had a picture of the one with the ink splodge on it. I don't think that would be the same in America. So having discovered these things, I thought, well, what does Parliament think about all this then? So I dug out Erskine May, which is parliamentary practice and their parliamentary handbook, and thought we'd better have a look at that. And the same thing is confirmed in this bit of text from Erskine May. The Act of Settlement affirms that the laws of England are the birthright of the people thereof, and all the kings and queens who shall ascend the throne of this realm ought to administer the government of the same according to the said laws, and all their officers and ministers ought to serve them respectively according to the same. The Succession to the Crown Act 1707, of course this was an anti-Jacobite measure, declared it high treason for anyone to maintain and affirm by writing, printing or preaching that the kings and queens of this realm, by and with the authority of Parliament, are not able to make laws and statutes of sufficient force and validity to limit and bind the Crown. Well, those words are very important. They're saying, in principle, if you just wrote a document up that said that the law was of insufficient force to limit and bind the Crown, you were committing high treason. That was not repealed until 1967. So that's pretty important. And nor was this a modern principle of constitutional law established for the first time by the Revolution of 1688. If not admitted in its whole force so far back as the Great Charter of King John, it has been affirmed by Parliament in very ancient times. So there we have it, Parliament's very own handbook, stating quite clearly that the law limits and binds the Crown and the government thereof. There is the actual Act of Settlement from 1701, and at the top, whereas the laws of England are the birthright of the people thereof, and ministers ought to observe them respectively according to the laws, a little bit underlined in red on the left there. So quite clearly the law is meant to be obeyed. I'll come back to this, but the Cabinet members swear oaths of office. The words in black I'll come down to in a little bit later on. MPs have a code of conduct. In their code of conduct it says that they have a duty to be faithful and bear true allegiance to Her Majesty the Queen, her heirs and successors according to law. Members have a duty to uphold the law and to act on all occasions in accordance with the public trust placed in them. Well, the public trust placed in them is to abide by our constitutional law and be in compliance with it to maintain the liberty of the subject. In an official reply from the Lord Chancellor's office, I managed to get them, it took me 10 letters to get this out of them. I would agree that we're all subject to the rule of law and that this is a fundamental and an essential principle of democracy, because I was asking them whether they could suspend the rule of law. And therefore we come to this fundamental relationship. The Constitution therefore should be all powerful, and Parliament is only a component within it. Our Constitution does not empower Parliament with unlimited or absolute power. Upholding our Constitution is the preeminent public duty of all who hold office. It should always be their certain policy. Well, it certainly should. This doesn't mean to say that the constitutional parts cannot be altered or changed. Some may or may not be entrenched. That's a separate argument. But what it does say is that there are rules of law that are written up, that are current law, and that they must indeed be obeyed. The degrees of entrenchment are another matter. We don't need to worry too much about that. We have written law that is current. The people's liberty is upheld at the discretion of their juries. Well, again, we mentioned that in the first place. And perverse verdicts are the ultimate common law proof of the limitation of statute. Well, of course, in the Ponting trial in the late 1900s, when Mr. Ponting decided to spill the beans on an official secrets issue, they pursued him in the courts, and they didn't like it. There was the spy catcher affairs and all those things, as you will no doubt recall. But the jury wouldn't convict him. They said, no, it was in the public interest, and we're jolly pleased about that, so Mr. Ponting was allowed to go free. So the establishment wasn't able to override him. And indeed, there's been a recent case, very important indeed in my view. Wang, a martial arts instructor, was mugged on a railway station and had his bag taken from him. I think he was in the loo at the time, and he managed to catch up with the thief and cornered him, and the thief at that point was opening the bag and discovered that it was a samurai sword within the bag, and said, oh, well, you're not going to call on your mobile phone, as he was, the police, are you, because you've got a bladed weapon in a public place. And Wang was having none of it and called the police, who of course came along and arrested both of them. And Mr. Wang gets taken to court, and the judge directed the jury to find him guilty of having an offensive weapon in a public place. So they appealed, and there was a unanimous verdict given in the House of Lords, in which the verdict was read that the judges said that they could find that there are no circumstances under which a judge may direct the jury to find someone guilty. Well, quite right too, but isn't it incredible that it should get to a court case where that had happened, that somebody had directed a jury that they must be guilty? An absolute offence, which of course is the nature of the administrative thing, versus the rule of law, which is about the common law and is centred on justice, which is to do with intent. Entirely different. Now, if we go back to the year 1530, one Richard Rose had poisoned the Bishop of Rochester's cooking, and he mortally wounded, it says in this act, 17 people. Henry VIII thought that poisoning was a very dastardly thing and would be treasonous, and that he should teach all poisoners a lesson. And so he passed this act against poisoning. It is incidentally the oldest act that I've handled from the House of Lords Records Office. But it's very nasty if you're Mr. Richard Rose, because this instructs that Mr. Richard Rose shall be therefore boiled to death. And he was indeed duly boiled to death at Smithfield, and I was able to confirm that. There's a little bit of text where it says it. Richard Rose shall therefore be boiled to death. And Hall mentions another act, that those who poison any person should be put into hot water and boiled to death. This act was made, adds he, because one Richard Rose in the Parliament time had poisoned diverse persons in the Bishop of Rochester's palace, for which act, in fact, he was duly boiled to death in Smithfield. Well, you can see that these powers could be very great indeed, and Henry VIII considered himself to be pretty dictatorial, and he had his Act of Proclamations in effect to put his word to be the law. But nevertheless, by and large, he tried to abide by the common law of the day. But Sir William Blackstone was quite clear that the Act of Proclamations was a treason at the time. However, what happened, of course, was that we came to 1688, and those powers were taken away from the Crown, quite clearly. And the Declaration of Rights has this text, that excessive bail ought not to be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. And therefore, if the Crown is under that obligation, how could it lend its royal assent to a bill to create cruel and unusual punishment? Now, if we ask a person in the High Street, what do they think about Constitution? Well, I say, well, we haven't got one, but the Americans have got one. And so there it is. That's the American Bill of Rights. And the ordinary chap understands that they have a constitution that's there to try and control their executive. and therefore it is a matter of the law controlling the powers of governance. Well, guess what? They copied parts of ours almost word for word. And there's the 10th article: excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. And all this is exactly the same principle, that it's about law being obeyed as a logical declaration beforehand of what behaviour must be in relating to the items itemised in the rules of law, so that we can all judge our actions accordingly. So the Americans have used exactly these same principles to build their constitution, i.e. its oaths of office, its written law that is agreed and published. In America, constitutional law is supreme. Now this is where we part with the Americans. In 1803 they had a contest, and it was called Marbury versus Madison, and conflict because Congress passed a law which was in conflict with the constitutional documents that were there. And Chief Justice Marshall made this. Chief Justice Marshall declared that in any such conflict between the Constitution and the law passed by Congress, the Constitution must always take precedence. Section 13 of the Judiciary Act, passed by the Congress in 1789, was found to be unconstitutional and thus invalid. They didn't have really a higher form or authority of law as such. It was just recognising the principle that there was a boundary, and if you went over the boundary, then something had to give. Well, it shouldn't be the Constitution that gives, it should be the encroachment by the new enactment. Otherwise, the Constitution clearly is mechanically useless or a waste of time. And of course, the means to get connected for the people back to their Constitution was to have a petition for redress of grievance. And of course, the Americans copied that as well from our documents, so that we could petition the Crown on a logical basis. And I believe that petitioning should mean that there are mandatory conditions upon the Crown under certain circumstances, if there is absolute violation of the fundamentals. Now, in 1929, Lord Hewitt of Bury was the then Lord Chief Justice, and he wrote this book, The New Despotism, and chapter 4 was entitled Administrative Lawlessness. Well, sitting the Lord Chief Justice to publish a book with administrative lawlessness as chapter 4 was a bit of a shock for the establishment, and so they decided that what he was saying was that in effect laws were being passed which were devolving powers to ministers to make rules and regulations, and when those rules and regulations were made, they would in effect be as if they were part of the law enacted by Parliament. So what Parliament was really doing was licensing lots of little despots, and of course this was the fundamental of the administrative system. And Hewitt said, well, this isn't justice, and complained about it, and he wrote this book, and it caused an upheaval, so they decided to have a committee on ministers' powers to see what powers ought to exist, and whether there should be Henry VIII powers, as they got known after Henry's Act of Proclamations, where he could declare things to be the law, and whether there should be Henry VIII powers available. And guess what? They cited the extreme examples of power of government, and they cited, that is how I found out about the boiling to death of the Bishop of Rochester's cook, they cited that as an extreme power that was open to Parliament to utilise. And they said, look, we could do this, and of course we could have Henry VIII powers if we wanted to. They were there, that's what was had. And they made no mention of the constraint and restrictions of 1688 and the Bill of Rights and the changes in the coronation oath at that time. So I believe that that report is ill-founded. Now that's rather important because, well, firstly, within the report is a wonderful bit of text, and it's a very good report in many ways, but this is very revealing. The most distinctive indication of the change of outlook of the government of this country in recent years has been its growing preoccupation, irrespective of party, with the management of the life of the people. A study of the statute book will show how profoundly the conception of the function of government has altered. Parliament finds itself increasingly engaged in legislation which has for its conscious aim the regulation of the day-to-day affairs of the community, and now intervenes in matters formerly thought to be entirely outside its scope. This new orientation has its dangers as well as its merits. Between liberty and government there is an age-long conflict. It is of vital importance that the new policy, while truly promoting liberty by securing better conditions for the life of the people of this country, should not in its zeal for interference deprive them of their initiative and independence, which are the nation's most valuable assets. Well, I think we'd all, without exception, feel that that's really come true. How much administration is restricting the zeal for interference? How much is that restricting the initiative and the independence of the people today? It's colossal. Well, they spotted it way back then, and we would give a lot to go back to the amount of law that they had at that time. Anyway, because of that report, that was in 1932, and then of course things fostered on through the 30s, and they tried to do things in line with that report. And of course the war came along and interfered, and then immediately after the war with the Labour government they decided that the best thing to do would be to formalise all the use of prerogative powers as orders and regulations and rules, and create statutory instruments so that they should all be numbered, and that all the orders and rules would be written down and numbered accordingly. And so this is very interesting, because this is the Statutory Instruments Act of 1946, which the whole thing comes alive from. And you'll notice quite clearly there that it talks about subordinate legislation on its title page. So it's quite clear that all rules and regulations, which most of us think of as being the law, because they are there, they're not the primary bits of the law, they're very much secondary area. And as you can see, it even admits on the front cover subordinate legislation. Now, just to show that there's been no shift in power in principle, bills are not enacted until they have their royal assent. And quite clearly here, what happens, everybody thinks the Queen should rush down to the Houses of Parliament, or a lot of people are under the misconception that royal assent is given by the Queen signing the Acts. That doesn't happen at all. The Queen delegates her authority, her royal authority, to her cousins, as they are referred on the document here, which is a letter patent, and unfortunately its photocopy in the black splodge at the bottom is the Great Seal of England, and it doesn't show up well there. But the Queen delegates her authority so that her cousins may pronounce her agreement to the acts that are listed on the schedule. And this is a very important document, because the central act of the acts on the schedule with the European Communities Act 1972. So this is the actual document, or the letter patent above, which allowed the royal assent to be given to the acts on the schedule. And there's also a very important bit of text there, because it shows that the power still resides with the Crown. And it's set forth in the schedule here too. But the said acts are not of force or effect in law without our royal assent. And so there you have it. The Crown still holds the power. And of course, what's happened is administration has got above itself, and they now believe that when the Constitution for Europe came along, that they're in a position to actually get to the point where the constitution and law adopted by the Union's institutions in exercising competences conferred on it shall have primacy over the laws of member states. Well, that of course is contrary to much of our fundamental constitutional position, which is cited at law. But here we got to the point where the administration and government of the day believe that it's just a question of them agreeing to these things, and off we go. And of course the Constitution became the Lisbon Treaty, and as we know that is currently held in abeyance, although our Prime Minister has agreed to its signing, so that has come through from the Crown. I mentioned the Privy Council's oath earlier on, we saw it, and the little black bit of text is very important because they all swear to abide by true allegiance to the Crown, and there you have it. You will to your uttermost bear faith and allegiance unto the Queen's Majesty. That's not the person of the Queen, it's the Queen's Majesty, i.e. the majesty of the institution of the Crown, what she represents, and will assist and defend all jurisdictions, preeminences and authorities granted to Her Majesty and annexed to the Crown by acts of Parliament or otherwise, against all foreign princes, persons, prelates, states or potentates. Very, very important. They don't seem to take much notice of that, and indeed Mr. Mandelson was rather embarrassed when questioned by Nigel Farage some time ago as he was taking up a position in Europe, and he got on News at 10 at the time that he was asked about his conflicts of his two oaths of office, but he just shrugged it off. Extraordinary. William Pitt, one of our great Prime Ministers, to say that if the Commons had passed an unjustifiable vote, it was a matter between God and their own consciences. Of course he was speaking from the Lords, and nobody else had anything to do. It was such a strange assertion as he'd ever heard. It involved a doctrine subversive of the Constitution. What if the Commons should pass a vote abolishing this House, abolishing their own House, and surrendering to the Crown all the rights and liberties of the people? Would it be only a matter between God and their own consciences, and would nobody else have anything to do with it? You would have to do with it, I should have to do with it, every man in the kingdom would have to do with it, and every man in the kingdom would have a right to insist upon the repeal for such a treasonable vote, and to bring the authors of it to condign punishment. I therefore again call upon the noble Lord to declare his opinion, lest he will lie under the imputation of being conscious to himself of the illegality of the vote, and yet being restrained by some unworthy motive from allowing it to the world. Lord Mansfield replied not. It's interesting, isn't it? Look at those words. And surrendering to the Crown all the rights and liberties of the people. Well, that's the situation we find ourselves in today. And of course, it isn't rightful. The law defines that Parliament isn't sovereign. The Constitution gives supremacy to the law, not to Parliament. That is the current law in force, the current law of the Constitution. It doesn't mean to say that Parliament can't alter it. They may or may not be able to alter the laws, but we only need really concern ourselves with what is in force. That is the current Privy Council's oath of office. The current Privy Council are sworn to it. If you go to their website, even a few months ago, as I did, you will see it on there. The coronation oath is the contract by which we must be governed. It secures the supremacy of the law over both Parliament and the Crown. Well, it's vital, isn't it? To pass powers of governance to those who owe no allegiance to the Crown, and thus the people, must be utterly unconstitutional. And they are unaccountable to, unelected by, not removable by the electorate of the UK, again, must be entirely unconstitutional. What happens to the laws being our birthright? Acceptance of the supremacy of the EU law is a subordination of our constitution to a foreign power. To accept the supremacy of EU law, the Queen will of necessity have to renounce her coronation contract to facilitate the dismantling of our existing constitution, or be put in breach of her oath. Well, it seems to me that that must be the case. And it's interesting that in the King of the Belgians did actually abdicate for a day to take a new coronation oath over Catholicism. Bowles versus Bank of England, very important court case in 1912. The budget failed, and Mr. Bowles is obviously a very wealthy man. I think he had a dividend that could have been in the order of £30,000, and the revenue came to tax him on it, and he said, not on your life, you haven't got an act to take my money from me, no taxation without representation, go away. So they said, no, we're taking your money. He took it to court and he won his case, and it was said the Bill of Rights still remains unrepealed. No practice or custom, however prolonged or however acquiesced in on the part of the subject, can be relied on by the Crown as justifying any infringement of its provisions. So that's very strong stuff. And then more recently, in 1976, we obviously in the late 60s we didn't have many colour television sets, and most of them were black and white, and colour was just coming in the late 60s, early 70s. And so they saw a chance to get a bit more tax, because there used to be just a television licence, as most of you will remember. And it, I think, cost £12 in the 1970s. And they decided that with the advent of colour television, they could get a bit more out of everybody by having a colour television licence. So instead of having just a television licence, we had a black and white and a colour television licence. And there was an extra charge of £6 for the colour licence. And Mr. Congreve, very brightly, went to his local post office right before the advent of the increase and bought a new television licence. And so subsequently the Home Office wrote, or Revenue, and said, you owe us £6 because your television licence has been outdated now. That's just for black and white television licences, and therefore you must pay up. And he said, oh no, not at all, my television licence is for television, and until it runs out in a year's time I don't need to pay the extra £6. Well, he advertised what he was doing, and 44,000 other people had done exactly the same thing. So it was very good. And I believe that he was a solicitor to the Queen at one time. And anyway, the outcome was that he went to court over it, and he won his case, and there's this wonderful statement by Denning. There is yet another reason for holding that demands of £6 be unlawful. They were made contrary to the Bill of Rights. They were an attempt to levy money for the use of the Crown without the authority of Parliament, and that is quite enough to damn them. Strong stuff indeed. The House of Commons, 21st of July 1993. Parliamentary privilege comes from the Bill of Rights, and so we see that when it comes to the House of Commons wanting to know whether the Bill of Rights should be upheld, they're very clear about it. The question of parliamentary privilege arose in this well-known case, Pepper versus Hart. Madam Speaker, the Bill of Rights will be required to be fully respected by all those appearing before the courts. The privilege is confirmed in the Declaration of Bill of Rights 1688-9, what has become known as Article 9. They're not actually numbered in the documents. But that's extremely interesting, because when it comes to Parliament and the Commons, for their use, we can expect the Bill of Rights to be fully respected. Well, that's extremely handy, because I think it ought to be, and it would do a great deal for us. Mr. Blunkett had a confrontation with some asylum seekers, and the rule of law let the asylum seekers go, and so there was a conflict, and this article appeared. Lord Wolfe was asked what would happen if there was a clash between parliamentary sovereignty and the rule of law. Because if you think about it, what I'm saying is that Parliament isn't sovereign, it's the rule of law that is sovereign. It's the law that is superior, not Parliament. His sober answer was the question ought not to be asked. And then the reporter, of course, very wisely, but it must be. And of course it's the law that must be superior, otherwise we have no constitutional restraint. And if we go back to Lord Hewitt's book, he noticed what was going on and put it very eloquently. But how far more attractive, and this was about talking about the ability of the administration to use administrative rules and regulations to undermine the actual fundamentals of the rule of law itself. So that's what he's talking about here. But how far more attractive to the ingenious and adventurous mind to employ the one to defeat the other, and to establish a despotism on the ruins of both. It is manifestly easy to point to a superficial contrast between what was done or attempted in the days of our least wise kings, and what is being done or attempted today. In those days the method was to defy Parliament, and it failed. In these days the method is to cajole, to coerce and to use Parliament, and it is strangely successful. The old despotism, which was defeated, offered Parliament a challenge. The new despotism, which is not yet defeated, gives Parliament an anaesthetic. The strategy is different, but the goal is the same. It is to subordinate Parliament, to evade the courts, and to render the will or the caprice of the executive unfettered and supreme. And what about that from 1929? Tell me we can't learn from history. It's utterly plain that that same trick is going on today. And that is what we're up against. And there are lots of insidious things. And one of them, I believe, is the Ministry for Justice, because it portrays justice as being something, as a matter for a minister's decision. Justice is about intent and about the people's decisions made in their juries. It's not about the autocracy of the state and its power. And therefore trial by jury are topical issues, presumption of innocence and intent, the right of self-defence, the Ministry of Justice, which I've just talked about, the House of Lords and the Supreme Court, or the Supreme Court that we're going to get. The judges are more appointed, or more nearly appointed by the politicians. It won't be long before they're fully appointed by the politicians. That's the whole point. How can that be governing us in accordance with our custom? I believe it to be utterly unconstitutional, inasmuch that there is no Supreme Court. There is nothing above the Supreme Court. There's no appeal into the High Court of Parliament, where, of course, our representatives sit in the form of the Commons as our MPs. ID cards, emergency powers, and of course DNA I haven't put up there, but it's another thing. Administration, devolution, fishing, fox hunting, right to roam. Under the right to roam, there was no compensation to landowners for any devaluation of their land. Alternative medicines are being regulated out of business without special certificates and so on. And so one's initiative and freedom and liberty is being encroached upon more and more. And the art markets, of course, are all coming under contracts for to be compliant with the VAT laws and so on. In terms of oaths of office, those who served in the trenches and the wars, some of them are under the most horrifying conditions imaginable, bullets and shell fire and all the rest of it, apart from the misery of it all. They had terrible conditions, and they couldn't get out of the trench and go and fight because they were too scared or they went weak at the knees. And they were held to be in breach of their oaths of allegiance to the crown. And some of them were shot and others court-martialed and so on. So some paid with their lives when they were under very trying circumstances. But it doesn't seem our MPs put the same degree of allegiance into their oaths of office as perhaps soldiers have been forced to in the past. Well, that's how it strikes me. The Bill of Rights is described by Sir William Blackstone as the undoubted duty of the King. So there you are, there you have it, one of our greatest judges making plain the duty of the state. All that I've mentioned here today is current statute law, as I pointed out earlier. And there are the current statutes that cite as statute law all the bits that we've mentioned. And so I think now that one can make a conclusion that we have no written constitution. Well, plainly there are lots of written bits of constitution, and therefore the no written constitution is false. We have a constitutionally limited monarchy. Well, you've seen how it was done. It was done by oath of office and by the rule of law, so that is true. The Crown accepts the advice of ministers. Well, surely there must be limitation. There has to be limitation. How can the Crown introduce cruel or unusual punishment or taxation without representation? Features of our Bill of Rights. Until that is repealed and taken out of the law, and indeed it was a condition upon which the Crown was handed over, which is obviously an entrenchment, and the coronation oath was taken at a time when it was the law. So by prior being, by grandfather right, our Bill of Rights must have some controlling duty to be inflicted and imposed on our politicians until such time as it's rescinded. It says it is the duty of all officers and ministers whatsoever, and therefore that is what it is. It is a matter of law. The Crown in Parliament is said to be sovereign. Well, yes, it's the Crown in Parliament that can make and unmake the law. But whether it can unmake all law is questionable, but it is certainly under the rule of law that is current at any one time. And then, of course, the other argument, no Parliament may bind its successor. And people talk about this endlessly. We don't really need to worry about it. This is a question of whether we should be ruled by dead man's shoes forever. Well, to that extent, one would say that, well, things ought to be ultimately alterable. Well, whether they are or they aren't, you can't use that doctrine that no parliament may bind its successor to undermine the law that is there for constitutional purposes and currently in force. But that is what is being done. People are trying to say, or parliamentarians are getting the impression, that there is no law to control or bind what their policies ought to be. And the people may not be separated from their courts. And that, of course, is utterly vital. But it is the object of nearly all administrative means, is to create direct mechanisms for enforcing the law, whether it's fines, direct fines, or so on. And so this was Lord Hewitt of Bury's great complaint, that the constant attack by the administration is always to devise means to separate the people from their courts, because it's administratively convenient. And therefore, I concluded that, in my view, the Constitution really means this. The rule of law, that is our constitutional law, limits the Crown and thus restricts the Crown in Parliament, and defines the role of Parliament and government and its relationship to the people, and the separation of powers. And that, of course, is absolutely vital. We have separation of powers. I believe that the Crown, Parliament cannot do what the Crown cannot do. And William Pitt, on this subject matter, instead of the arbitrary power of a king, we must submit to the arbitrary power of the House of Commons. If this be true, what benefit do we derive from the exchange? Tyranny, my lords, is detestable in every shape, but none so formidable as where it is assumed and exercised by a number of tyrants. But, my lords, this is not the fact. This is not the Constitution. We have a law of Parliament, we have a statute book, and a Bill of Rights. And therefore, I conclude that under the rule of law, there can be no divine right of politicians. It's a pretty simple and it's wonderful. And to tell me that you can't learn from history, history is so plain. And when in subsequent ages the state, swollen with its own authority, has attempted to ride roughshod over the rights or liberties of the subject, it is to this doctrine that appeal has again and again been made, and never as yet without success. Well, that is what we must do. We must appeal to the doctrine, and the doctrine is the rule of law. Thank you very much.
Well, thank you very much. I think we'll best now have a break, a little rest. Now, we're all refreshed, as we needed to be, after this great exposition by John, who begins by telling us he's no registered expert, which means he hasn't written several volumes of books which nobody bothers to read, but himself has really researched the whole business of the Constitution from the Magna Carta onward. And I think what we've had this afternoon is a really splendid recipe of the whole system as it began, as it proceeded, and as it has been twisted and turned to the situation we are finding ourselves in now. Completely different from the Magna Carta and the Bill of Rights, under people who wish us nothing but complete evil in changing our Constitution and our freedom into the misery of a super-state under Marxist regulation. Now, I think, is the time for you to explode with your questions. If I may ask one at a time, so that everybody gets a chance. Off you go. Numero un.
When you discuss constitutions with certain philosopher people who think they know all the answers, they will say, are you saying that a constitutional piece like the Magna Carta, which we all admire, and the Bill of Rights, are you saying that's entrenched forevermore and can never be changed? And if it can be changed, for instance, there's some clauses in the Magna Carta which are totally out of date, obviously, because the civitas don't pertain anymore. But are you saying that they cannot be changed? I haven't heard you actually say that, but if they can be changed, who could change them?
Well, I've only talked about what is actually current statute law this afternoon. So really the argument is, as far as I'm concerned, superfluous. It's an important argument, it's an important subject. Should we be able to undo that which has been put in place perhaps a long time ago? The answer to that, I think, has to be ultimately yes, one does. But one must look at the wisdom of it. And the rule of law gives us mechanical means by which such things ought to be done. So when one talks about an entrenchment, which is what you're referring to, is the entrenchment of legislation, to say that everything is so fully entrenched it can never be altered is a fairly strong position. Maybe circumstances arise in the future where it cannot actually be put forward in that way anyway, as a thing originally intended or proposed.
The reason I ask that is because there is now a commission, the Human Rights Commission, which is actually considering a Bill of Rights without even making any mention of the fact that we actually have one. And also I did fight a court case on the parking fine and used the clause in the Bill of Rights, so no fines and forfeitures without conviction, this one, are null and void. And NPAS, National Parking Adjudication Service, I presume you've heard of them. They're the people that actually have a tribunal and so forth. They actually wrote my case up in the Parking News and saying that the Bill of Rights was built for another era and doesn't apply.
I think that is utterly wrong. We've seen from what the Speaker's comment is that the Bill of Rights will be fully expected to be fully upheld by the courts. And the Bill of Rights is of great importance. Most of the things that it deals with are very fundamental. And so they're not things that you talk about whether they're entrenched or not. The point is does society want to do away, say, with taxation without representation? If it is that you think that you want to have an authority, an administrative authority over this that can just tax at will, then get rid of that bit of the Bill of Rights, because that part of the Bill of Rights, no taxation without representation, knocks out the power of the Crown and the institutions of the Crown to tax arbitrarily. So that's what I'm saying. We don't necessarily have to worry about this. Everybody worries about entrenchment and whether it's entrenched or whether it isn't. It doesn't matter for the fundamentals. No taxation without representation is vitally important. So is the freedom of speech in Parliament. And so are no fines and forfeitures without conviction. Now, all these things, they all have to be interpreted by the courts. And the question is, what have the courts decided on many of these issues? Well, the fundamental issue that I'm putting forward has never ever been contested. And the issue that I'm putting forward is that of Marbury versus Madison. Which is supreme? The rule of law, and that is, when I say the rule of law, that is the current law in force, that is there to be seen and read by everybody, the current statute law, and the current statute law gives Parliament a purpose, and that purpose surely is redeemable, as it were, by the people through their courts and by the mechanism of petition of right.
Sorry to take up so much time on it, but there's one...
You mustn't take more than one question.
No, this is related in that you say it should be taken up by the courts, but the trouble is the government is avoiding the courts by going to these tribunals like the National Parking Adjudication Services, which is not a proper court, and they come up with all sorts of...
That's right. Well, that's why you have to get back to the law, and bear in mind that I showed a picture of this Statutory Instruments Act, which makes quite clear that all those sort of things are rules and regulations that are set up for administrative purposes. They're not the fundamentals of the rule of law itself. And the rule of law itself determines the separation of powers within the state, and that's very important.
Okay. Yes, John, I believe that at the end of the Bill of Rights there is a wording which states that the Act can be amended, but not beyond a certain date in 1789, October, I think it was.
It's 1689, yes, that's the clause about non-obstantes. Now that bit is actually not on the Declaration of Rights, it is only on the statutory form, the Bill of Rights, and has indeed been repealed. It was only relevant as to whether there were amendments, it was only intended to be relevant whether there were amendments until that time, and there weren't any, and so it was actually utterly irrelevant and doesn't come into the equation.
So it doesn't relate to the whole of the Bill of Rights, of the Declaration of Rights.
No, it doesn't. No, it relates to the Bill of Rights.
So, that's what I meant. Sorry, Bill of Rights. But
yeah, no, it doesn't. But there are other bits that fulfil more or less the same purpose, which mainly people perceive that being.
yes, I see.
Next question.
Yeah, I mean, I'll follow on from that, but what it actually says is any amendments after the 23rd of October 1689 are void and not lawful. It doesn't put a cut-off date on that. It leaves the cut-off date open. So presumably they are there for all time, and in fact it says this bill is for all time. So I would suggest that in fact they are not permitted by the people who actually put the Declaration and the Bill of Rights together to actually alter it. Would you agree or disagree with that?
It has been repealed from the statute. The Bill of Rights is a statute. That bit is only statutory. It is not in the Declaration of Rights.
No, I understand that, but William took the people who'd actually produced the Declaration of Rights, and he appointed those as his Parliament when he called a Parliament. It was a short Parliament, only lasted for 6 months. And the first thing they did was pass the Declaration into law as the Bill of Rights. So it's exactly the same people who did it, the representatives of the people who produced the Declaration, who actually put the Bill of Rights in. And therefore I don't see that there is any way that Parliament can override that, because it was the same people who actually were specifying this.
It's an argument of, it becomes an argument of entrenchment, and the question of dead man's shoes again, which is where we're coming from. For the purposes of, it didn't actually affect anything really within the issue. So it's only a question, what you're actually asking is, are things totally permanent or not? And that was an enactment, it was part of an enactment that was repealed.
But if you take things like Magna Carta and the Bill of Rights and things like that, these are simply the Charter of Henry I and various other bits and pieces that have gone through. These are simply restatements of the law as it was under Alfred's Code. These are simply restating the freedoms and the rights of the ordinary free man of England as it was under the Code of Alfred. So it has been consistent now that we have had the same rights and freedoms which have been reinforced periodically whenever a king like John has got out of, or James has got out of their pram and done something wrong. These rights and freedoms have in fact been consistently reiterated and reinforced, but we can actually trace all of them back to King Alfred, and Alfred took them from prior kings from the smaller kingdoms in the country, and when he selected the best laws and customs of all of those kingdoms for his book to Dome. So what we are talking about here is a set of rules which have become entrenched through use.
Common law.
Yeah, what I was just going to say, this is really the fact of common law, isn't it?
Yeah.
And the custom, of course, is part of the coronation oath.
Yes,
Recommended by the coronation oath.
And Parliament, in my belief, and I suspect from your what you were saying earlier, Parliament can only legislate within the confines of our ancient constitution. They cannot legislate outside of that, because exactly the minute they step outside of it, whatever they are doing is voided by the Constitution.
Well, I think this was covered partly in my
That's exactly what I'm
lecture.
saying.
I don't know whether
Yeah.
you saw the bit by Lord Hewitt of Bury, but he referred to in his report. In the Minister of Powers report, and it said about they were actually quoting sub-quoting a bit written by Macmillan, and they were saying that matters formerly thought to be outside its scope, referring to the authorities of Parliament, and they were widening the scope of Parliament's authority. Now, what you're saying, and which I have much agreement with, if I've got this right, is that the job of Parliament is to maintain the liberty of the subject, not the subjects as such, but the liberty of the subject. And through maintaining the liberty of the subject, i.e. maintaining the liberty of the subject for their spiritual and civil rights and properties, by doing that, it looks after the nation as a whole. But if I may just say, Albert, let me just speak out, that this is very important, because it means, therefore, the government really has a job to look after the liberty of the subject more than to speak for the whole of the nation, as the administrative machine tends to do. There are degrees of that, obviously. Everything is about degree.
For the greater good, they will say.
Owen,
My feeling with Parliament
just
in
a
fact...
minute, there's a question.
Yeah. Okay.
Owen?
It seems to me that we are digging back into history about what people decided 2, 3, 4, 5, 600 years ago. It cannot be, in my view, that decisions of that antiquity are necessarily correct. The assumption that merely because somebody said it X years ago, this is for all time correct, seems to me to be absolute nonsense. There must be an ability of current populations to enact laws that they see fit for the purpose of the day.
Well, I think that's right. I don't disagree with that. But what I'm saying to you is that we have a Bill of Rights which does very fundamental things. One of the criticisms of it at the time was that it didn't go far enough. But what did it do? It produced a civilizing influence over torture and cruel and unusual punishment. Well, pain has been felt by human beings ever since they've been around, and they pretty soon learned that it wasn't a very nice thing to have about, and certainly not inflicted by others. And so the fundamentals, like no torture, although they're old, they're fundamental. And so we don't need to worry about the antiquity of the Bill of Rights in that regard, because that's what it deals with. It deals with rights of no taxation without representation. I mean, that's a very fundamental thing. Do we want to be taxed? Do we want to say, well, that's old law and now we'll allow Parliament the power? Because what this did was about what power ought the governing authority to have. That's what the Bill of Rights is about. And okay, if you say, right, we need to change that today, let's face up to that and say, well, the Queen is actually sworn into a contract with this whole system, and we now today decide that this has got to be broken because it doesn't fit modern circumstances. We need to have direct taxation or whatever it is that the thing is. Then you can have a debate about how you're going to shift the power of the governing authority. But if you don't keep to the rules whilst they're there and on the statute book, then anything can happen, and that's where we're going adrift, in my view.
Mr. Hudson.
I think, have we or have we not signed the Treaty of Lisbon? Because I'm very confused here on what it means to us.
I'm sorry, what was the question?
Have we or have we not signed the Treaty of Lisbon?
I understand that it's been signed, yes, that it's been agreed.
Delivered to Rome.
And delivered, yeah.
And has any other European country disagreed with it?
The point is that the treaty doesn't come into being until such time as it's been ratified by all parties. So firstly,
All countries?
All the countries, yes.
Right, okay.
Yeah, so the Irish referendum scuppered the universal,
I see.
so it hasn't come into being. course Europe's going to try and do it. I believe that it's passing powers of governance to a foreign potentate, and as such that is contrary to the current Privy Council's oath of office. And this is a good point about what Owen was just mentioning just now. You're saying, well, we need laws for the current time. But, okay, the current Privy Council's oath of office is the same oath of office that was sworn at medieval times. And it prohibits the transfer of power to a foreign potentate. Well, if it is that we want our government to transfer power to a foreign potentate, then we should relieve them from that oath of office, and they should come clean and say we need to change this oath of office because of this prohibition, and therefore we're going to put this matter to the current population. But that, of course, never happens.
Yes, ma'am.
Could John just explain why Germany hasn't signed the Lisbon Treaty?
Yeah, these are...
haven't ratified it.
Yes, well, again, they have a constitutional position of their own, and it's being attacked in the courts in Germany. And I think that is partly holding it up. But to be frank, I'm not familiar with that. It's not my territory. I'm the rights person. But, yeah, there are all sorts of reasons, obviously.
I'm coming back because, John, I put quite a few points to you in my first submission. And you didn't really answer the questions. If constitutional was above Parliament, as we understand it, according to your Bill of Rights, is superior to Parliament, as Magna Carta is. If it's going to be changed, we agree that it's not fit for the present time, as Lauren says. And who has the power to change it? To me, it's only the people. Have you read Tom Paine? Tom Paine
bits of it, yeah.
Will say that constitutions, governments have no right to involve themselves in constitutions or changing constitutions. If that is true, then who does have the right to change constitutions?
Well, quite a good question. I don't need, from my own point of view, I don't really need to be involved with it particularly, because all I'm saying is, look, we've got constitutional documents that lay down rules. They've been agreed to, and they've been agreed to currently, and they mean something. And therefore we ought to be able to enforce it as it is. Now, if we want to get into the business of changing what is written down in those constitutions, that's another matter. Let's get to it. Let's have
another matter because
let's have public debate about it. But what's going on at the moment is abuse of power. Okay, they're just going ahead and outside of that, in my opinion.
One more.
That was basically my question. How would one go about changing an ancient law like the Bill of Rights? But you use the word entrenchment. I mean, that's like an arbitrary definition. It has no legal force, has it? In essence, it's just a word that's used. It's arbitrarily entrenchment or non-entrenchment. Well, it has no legal significance. It's just
there would be the way in which you can talk about double and single entrenchment. And so, if you make it a law for somebody to have a duty to do a certain thing, and then, for instance, make them take an oath of office that whilst they're under that oath of office, they must do that thing. They surely ought not, until they repeal their oath or relieve themselves from that oath of office or that position, seek to undermine what the duty is that they've been put in place
are these people therefore guilty of treason?
Well, that's absolutely right, yes. Under the terms of the Thistlewood judgment, which was in the 1820s, it was held that if you sought to undermine the fundamental law of the Constitution, it was treason, because that was a subversion.
The point is, not long ago, quite a lot of people in different parts of the country went to police stations and said that the government was committing treason, so citing the Bill of Rights. Would it not have been possibly better to have said that the various peoples, and we could name names, who committed treason because they've forfeited their oath?
I think treason's a very difficult area. Are you going to start taking people out and having them, hung or what have you? I know that lots of people would say yes, it would be terrific, and as Lord Hewitt-Berry pointed out in his book, and somebody said, well, there wouldn't be enough lampposts to go round. It's part of the joke. What I think one has to recognise is that this is a situation that has evolved over a period of time, not necessarily at any single one person's behest, although we would all point the fingers perhaps at particular areas where there's been a concentrated change, and there has been deception, as we understand it, from Ted Heath and so on over the European Union, which he admitted to, so I understand. And now those things, yes, that one can't deny that they're in conflict, and you can see when it was a matter of convenience for the government to have rules against writing, printing or preaching, that the law was of insufficient force or power to limit and bind the Crown and the government thereof, they turned that into treason against the Jacobites who wanted to have the Jacobite kings back in place. So things have changed, but the principles of the rule book are there, and it seems to me that we ought to be able to use the principles to get back to what I consider to be the rule of law, i.e. the Bill of Rights controls the governing authority.
Right. We're talking about Parliament passing new laws for the modern day. I have a tome at home, roughly the same size as this, which is the parliamentary report on the new Bill of Rights that they are proposing. Paragraph 4 on page 106 gives them a legislative override, so that they can, by passing an act through Parliament, remove any laws that they want to, which means they can take away my rights and freedoms. I've had those, they go back to they predate Alfred the Great. Nobody on this planet has the right to remove my rights and freedoms. I'm not prepared to give them up. Now, I took exception to this, and I wrote to the Parliamentary Committee, 6 Lords and 6 Members of Parliament. I have a letter at home from the clerk to the Parliamentary Committee, in which he very facetiously tells me if I want to go down my library I can learn about the Constitution. But he does say that there is an interesting constitutional debate going on at the moment as to whether Parliament, by passing a law, could undermine or abolish the rule of law.
Right.
This is what they are talking about, abolishing the rule of law. Now, I hold very firmly, and I would hope, Mr. Bingley, that you would agree with this, that in order to abolish the rule of law, they would quite definitely have committed treason. They will have committed treason because they will have totally subverted the constitution of this country, and to subvert the constitution of this country to that extent is not the crime of sedition, it is the crime of treason. Would you agree or not?
I think I have to agree with that. I can't see how it can be otherwise. The rule of law is there to defend the liberty of the subject. And the whole point is that parliamentarians sit in Parliament to represent the will of the people for the purpose for which we defined to put them in there. It wasn't an unlimited purpose. They have a job to do, and the job is the maintenance of the liberty of the subject.
I
find terribly simple and important.
I see Parliament as the housewife of the nation. They are there to take care of the day-to-day administration of this country. They are not there to get involved in major constitutional changes without first obtaining the permission of everybody else in this country. They are there to make sure that there is water coming through your taps when you turn them on, that there is electricity to feed your light bulbs. That is what they are there to do. They are not there to decide that they know best.
Anybody else?
Yes, Nick.
Thank you, Harry. First a comment, then a question, John. In the last 10 years we've seen a tremendous drift in public and personal freedoms and in the powers of the Member of Parliament in Parliament. Suddenly a week ago they all woke up as the terrorist police wandered through and ripped off somebody's office without even a warrant. But do you or do you not think that the real fundamental problem we have in Britain is that we've got the best law that you can buy?
What have we got?
We've got the best legal system that you can buy.
Oh, I see.
And providing you've got as much money as Aristotle Onassis had, then probably you can buy a great deal of good law that enforces the things that have just been
Well,
said.
there's little doubt that the administration has used that tool against the people to forward administrative rules and regulation, without doubt. Yes, I think there's a lot of comment on that. I mean, many people would feel it. One of the things that I've had an ambition to do is that it may seem like a dream world, but I've always felt that if one could somehow obtain, say, a fund of perhaps £100 million or something of that order, which could be collected universally, and after all it's not huge money in governmental terms, one could create in effect a pension fund that would reside for the purpose of taking up on behalf of the people constitutional infringements by government, and so that when government passes laws and where they can be shown to have infringed the fundamental liberty of the subject, that a system like that could step in and take up the challenge and pay for it and advertise the consequences in the press and so on, and be an unassailable fund. And once it was there, it would never go backwards. It would be there to hold its level and constantly take up issues. Self-financing, yeah. And I think we do need it. We need a levelling of the field and that on the financial basis.
Would that be privately operated?
I think it should be, yes, yeah. Well, I mean, maybe it could get an initial government grant to get it going.
I think you're running into difficulties here because you're going to have two standards of law.
Yes. Why not?
One law that you can't change, another law that you can change. Who made the first law?
Well, I don't quite follow that.
I think the point we're trying
reason.
to make, Owen, is that law is so expensive that only very rich people can afford to go to law, particularly to take on the government and government departments to prove that they're actually breaking the law that they should be
But I
enforcing.
think there is a danger here that you have a law that says you shall have a rear light on the back of your car after dark or something, and you have a law that says thou shalt not kill.
Yeah.
Now, is one law better than the other? Is one law somehow sacrosanct and the other isn't?
Again, I think, can we come to, again, a fundamental here, is people look for divisions in our law. And, of course, we know the Metric Martyr case in which Justice Laws declared that there was a level of constitutional laws recognised by the common law in recent times. But we don't have to be, again, necessarily involved with that, because I think what describes whether a law is constitutional or not, not entirely, but one of the critical criteria must be what's its objective. And the objective of the Bill of Rights was to confirm the Declaration of Rights, whose purpose was the authorities that the Crown could have and the limitations to the use of its prerogative power. And that was the purpose. So that's what made it constitutional. So it does set it into its own category, because it's saying that you, the Crown, who hold the power, and it still holds the power, even if only theoretically, you saw the letter patent, bills are of no force or effect without this our royal assent. It is the Crown who holds the power under contract from the people. It's quite plain. And so that makes the position of constitutional, or of the Bill of Rights, a constitutional law. And then you come to the question, is, for instance, the clause about fine or forfeiture says that if this is violated, the things that violate it are void. So what do you do? No doings or proceedings to the prejudice of the people in any of the said premises shall be taken into consequence or example. Now, and it also says that this is the duty of all officers and ministers whatsoever. Now, all of those phrases, it goes further. It says shall be esteemed, allowed, adjudged, deemed and taken to be. There's definite authority to the judiciary, adjudged, and to the Crown. So it lays down the policy of government. And I believe that is the policy. It ought to be the policy, it ought to remain the policy until such time as it's removed. Now, if government does things against that policy, we ought to be able to challenge it. Now, as I mentioned in the presentation, in America they had their case Marbury versus Madison. Now, we have never achieved a Marbury versus Madison. The issue of the supremacy of the law over Parliament as such, and in effect the supremacy of the limitations on the Crown against the laws that are being passed, has never been put to the test. And that's what we need to do. We need to get that precedence into court and proven. And once that precedence has been won, and I believe it can be won on this logic, then the ball game should start to move back.
£100 million.
But what if the Crown, of its own will, relinquishes its statutory and its position to a foreign power? What's our position then?
Well, it must be unlawful for the Crown to do so, mustn't it, according to the existing constitutional rules and regulations. And therefore we are, the subjects, under the terms of Magna Carta, of course, become relieved of our allegiance.
This is what I'd like to bring up, because I've written to the Queen, and other people have. I mean, going to that, there's the Crown. In the past, the King defaulted, and the people, and the King John, as you said, had to step down and agree to be under the rule of law. Now the Queen, she's signed all these treaties, and if you write to her Sonia Bonici just rubber stamps your reply, and the letters are passed to the FCO. And you do not get a proper reply, and so Sonia Bonici has actually said to Brian Gerrish that, oh well, this is all to do with the EU. You know, immediately they bypass these things, and you cannot. So it's all topsy-turvy now. The Queen is. Has abdicated all her responsibility, and so it sort of turns on its head this business of the Bill of Rights, that the King, the Crown, William and Mary bowing to the Bill of Rights. Now we're in a different situation, and I feel we need to agree on a strategy of how to tackle this matter. I mean, is this Albert who's done this, the treason business? Well, we need to take it a step forward now.
It's Albert sitting there impatiently wanting to come back.
Well, firstly, let me say, we have not had a legal parliament since 1911, when they put the Parliament Act through, and they destroyed the checks and balances by refusing the Lords permission to reject a bill. We have not had a legal parliament since a government minister told George V, play that, kick me when I do that, told George V that he kept all of his prerogatives, but he could only use them if he had the backing of a government minister. The one prerogative we want the King to have is the ability to say no. So that's on that one. I'll pick up some points made by these two gentlemen here. Firstly, the arrest of Mr. Green and the searching of his offices without a warrant. For my sins, I was a police officer. And I'm going to tell you that members of Parliament are not immune from the effects of the criminal law. They are there to say things in the House of Commons for which they can't be done for libel. That's fine. But if they break the criminal law, then they are subject to the rule of law, the same as you and I are.
But so are the police.
Right, yes, and exactly, and the police conformed fully with the rule of law. If a police officer arrests you, he can ask his inspector, under the 1984 Police and Criminal Evidence Act, to search any premises or vehicles which you have control of in order to collect evidence of the offences for which you have been arrested, and without giving you the opportunity to destroy that evidence. Now, this is a piece of legislation passed by Parliament, and it is a housekeeping piece of legislation. The construction and use regulations designed to make sure your vehicle has a red light on the back are there because all of us under our constitution have a right to cross the road without being run over. And therefore they have drawn up regulations in Parliament with regard to the vehicle's construction and how you can use it, because under the construction and use regulations you are not permitted to road race your car either. So, no.
For a long lecture.
No. But no, I'm just clarifying the points here. That the police, in fact, when they enforce the red light that you haven't got, are not enforcing a constitutional law. That's a normal housekeeping law. When the police search a Member of Parliament's office without a search warrant, they do not require one. That is housekeeping law.
I see.
Somebody at the back wants to. Did you want to say? No. Nobody. Any more?
Oh yes, I did want to say something. This is a slightly off the subject, but can you tell me by what authority can a government declare war? I'd like to know, is there any constraint on the government to prohibit them from going to war? Because we seem to be, in that sort of case, we seem to be living in a dictatorship.
Well, certainly the Crown traditionally is allowed to attack its enemies, and I suspect that the judge of that is entirely in the hands of the Crown.
Yes. Well, what defines what is illegal or legal with respect to
I think that taking us to war has been a prerogative of the Crown. It hasn't been constrained as far as I know.
So there's no question of legality or illegality to do with it?
I don't think so. I think it's an executive decision.
So you can't talk about an illegal war then?
No.
I think it's a difficulty.
You can under international law.
Yes, or international laws of Geneva Convention and so on. Yeah. An area with which I'm not acquainted.
The 1972 Communities Act, is it possible to repeal it, as the Conservatives say they would do if they got it?
Oh, of course. Any act of Parliament is subject to be repealed.
Will they?
No, they won't.
Another matter.
Majority, they might.
You see, I think that we've answered the lady's question at the back there to some extent. It seems to me that all this is a question of degree, and we've gone down the wrong road. We've taken the wrong road. The probable answer is that if we get a correction, rather than recrimination, there would have to be acts of indemnity to say, well, what's gone before was a mistake and we'll have to rectify it and turn our way back. I believe that my answer of the case, the Marbury versus Madison, is a good one, because it would mean then that you wouldn't have an immediate and great change, which would create enormous difficulties. Court judgments would come in and slowly turn things round back in favour of what ought to be our true political policy, which is the liberty of the subject and keeping the laws to the birthright of this kingdom, of the people of the birthright of this kingdom. So I think that degree it's very important to look at these things with degree, and it will take time, but yes, I think things can be repealed. What needs to happen is there needs to be an awareness, a general awareness. You're not going to get the things upheld in the courts unless you can create a political clamour for it. At the moment, the political parties don't consider it to be in their interest, and that's one of the big problems. But the Romans had a very interesting way of looking at political power. They divided it into imperium and autoritas. And in essence, imperium is the muscle, and autoritas is the public authority or accountability of it. And so good political power is utilised with authority of the public and the necessary force to put it in place. And of course what you see is if you start on the road to tyranny and despotism, you get an imbalance, and it becomes imperium, and the autoritas goes a different way. And of course we can see that division happening today. The politicians are going down their own road. and the public are going a very different road. And I think we need to make the fundamental issues aware, or the people aware of them. And I think that if much of what I've got to say can be put into sound bites like no divine right of politicians and so on, that and the liberty of the subject, that should be the policy. Those things are marketable, as it were, in modern parlance. And I think that's what we've got to sell, make people aware of it, get it out there. And it's a legal fight, but it's a legal and a political fight. It's got to be fought in both fields, because it's no good just having one person shouting about it, because it just steamroll it out the way. Yeah.
Yes. David?
You know you've got an expert rival who attends the Marlborough Group from time to time, who thinks that Parliament is supreme. Going further on that, I used to have email exchanges with David Cameron, my MP, until I sort of went a different direction from him. But one of the email exchanges I've got is, I was asking this very question about Parliament being supreme, and he replied that his professor at Balliol at Oxford University, Vernon Locknedor, do you know him? Locknedor.
I know the name.
I'd always said that what Parliament deems is the law. In other words, David Cameron thinks that Parliament is supreme, and that's because his Oxford professor told him so. So somebody is giving false information from the very top down.
Well, may I just, again, this is so, it's all words and minor deceptions. Yes, Parliament is the supreme lawmaker in this land.
Yes, that's right.
That is correct. But that doesn't absolve Parliament from being bound to the duty that is depicted in the laws which are constitutional in content, namely our Bill of Rights. And therefore that charges the Crown with the duty, and the MPs and all those in ministers and officers of the Crown are all bound by true allegiance to the Crown.
I went on to ask him if
that's not an unlimited job, is it?
If that is the case, then can Parliament abolish itself? And he replied, yes, I suppose theoretically it could, but if it did so, I'd be out on the streets. So that's be interesting to see him.
Absolutely, but if I'm mistaken about this, so was Lord Chatham. You saw what he said in my earlier thing, abolishing this house, abolishing their own house.
That's not an argument. I'm just giving you a point of.
Quite. Yeah, you should have to do with it, and I should have to do with it.
We'll have an opportunity of Michael Shrimpton being here a month's time, 4 weeks' time. So I hope that Harry will announce that anyway.
Are you coming back to give him a hard time?
One final point of what you were saying is that in the final analysis, the power lies with the people. Let it never be forgotten, correct? If the people are aroused sufficiently, no power can withstand them.
Right.
Well, that's right. They'd be absolutely brain dead at the moment.
When various contentious issues have been put to the law, the judge has ruled in favour of the European Union law being supreme over our own. Now, are those judges, have they been correct?
Well, interestingly, in the Metric Martyr case, it was very clear in Lord Justice Law's response that there can be no breach or loss of sovereignty. He's perfectly clear on that. And that, of course, is what must be, mustn't it? That has to be the case.
So they can't rule in favour of the European Union as being supreme then?
I think you have to, again, it's partly about domestic policy and the liberty of the subject, and then, of course, there's our legal relations with other countries and on the international field. That's a slightly different area. But when the Crown makes treaties, those treaties in the past, at least, weren't normally expected to impinge entirely upon the rights and liberties of the people within the land.
What about these extradition treaties which we made with the United States, which seems to favour the Americans? They can just pluck somebody from this country and take them across to America? What about the rights of the individual in this country with respect to our constitutional law? If Parliament is there to fundamentally to support the civil liberties of the individual, what about the civil liberties of those people who have extradited to the United States? Has the government been correct or ethical in
I think
that treaty?
Well, I think there's a simple answer to it. In my view, that is again unconstitutional. But that should be argued and clearly argued in the courts.
Yes.
I hope that it will one day. And one of these cases, one of these issues, is capable of being the Marbury versus Madison, if it's properly launched in a court case. I had hoped that I was involved with that Stuart Wheeler's challenged the referendum. And indeed, I was instrumental in starting the whole thing off. And initially, it was going to be a court challenge based on the things that we've put forward today. But for reasons unknown to me, it changed and became an issue about the legality of the referendum. But I hope that at some time we will get a case.
If we were to get such a case and it was successful, it would set off an avalanche, wouldn't it? Cascading right through the system, and then destroy our raison d'etre for being in the European Union and everything, to undermine the whole lot, wouldn't it? So it destroy their cases, the situation, to show that it's a total phony that we're in.
Yes, Margaret.
John, could you not produce a simple leaflet which people like me can take? I go around markets and that sort of thing and read things out and shout things out. Could you not produce a simple leaflet with sort of little paragraphs which are easy for ordinary people to understand?
Well, it may be that one could produce something of a leaflet. I mean, that's why I've been doing what I've been doing, because I wanted to try and empower people against overmighty governance, as I see it. Until we can get people to really take up the challenge that government isn't there just to do as it wishes, but it has a job to do which involves our liberty.
The fact that Mike just brought up that question about people being extradited to America.
Yeah.
Well, we know that when they get there, they're tortured, isn't that? You've just mentioned that that's against our law. So
It's not against their law.
What?
Not against their law.
Well, I think it is at a fundamental level, but it hasn't been challenged. It's not been challenged in the court.
Stuart Wheeler did get such good support when he brought his case. Could we not persuade him to bring a case and people to donate to it, as they did do to the...
well, originally, yes, but the amount of donations that he got, I don't think was enormous. He did, I think, reasonably, but he underwrote it all, and of course he went away with quite a bill. So, yes, very generous of him.
Going back to the topic, Bill of Rights, you did mention the Bill of Rights says that no man can be exiled. Isn't sending somebody to Europe under a European arrest warrant, isn't that exiling somebody?
That's Magna Carta.
Sorry, Magna Carta. Okay,
yeah.
Same question though.
Yeah, well, I would say it is. Yeah, I mean, I think that appeals to the fundamental doctrine are terribly important.
Yeah.
But unless you understand that, what happens is that people who are under these things will go to modern lawyers, and modern lawyers will take the view that the de facto situation, and the de facto situation isn't what I'm telling you. What we're getting today is that Parliament is sovereign and can make any law it wishes, which is actually an abuse of what Dicey and so on.
Well, can I suggest that people use the press as much as they can? For instance, in Whitney, where I live, they've just introduced decriminalised parking. Well, you know what all that means. And so I took the opportunity to write a letter telling the public that that this decriminalised parking was illegal according to the Bill of Rights, and I quoted the expression "no fines and forfeitures are null and void," etc., etc. And there was no challenge. There was one challenge from somebody who doesn't like me, but he made a ridiculous. There's quite a few of those. But that was quite easily shot down. In fact, Ken Nikolai Tolstoy, who is our parliamentary candidate, helped me write the response to that one, and there's been no further response. But of course the council will still go ahead and implement decriminalised parking. But of course people will now know that it's illegal.
The only winners here are the lawyers always,
We
aren't
only
they?
have a few minutes left, so I think we'll give one more chance to our police friend who's dying to say the last word, but cut it short.
An excellent piece of modern legislation, which in fact would fit the bill of a court case under the constitutional law, is in fact the Anti-Terrorism Act, because that allows detention without trial and without charge for 42 days. That is contrary to Magna Carta, habeas corpus and the Bill of Rights. So when we run through our constitutional law, Parliament have passed a law which in fact drives a horse and cart clear through the Constitution. And if we want to do something, then we need to do something which is patently obvious to your Cockney orange seller as well as your lawyers. In fact, you're wasting your time with lawyers because they are all taught today.
And
There's no such thing as treason. It doesn't exist. It's not taught in law schools. Police officers are not taught treason, and in fact they are all taught what Parliament does is right, irrespective.
Can I just sum that up for you? It is a legal battle that's got to be fought in the political field as well, and therefore it needs to be a very simple and plain issue that everybody can understand and which the public will get behind.
And in here in this room, so we'll get the chance next month, right? 4 weeks' time, Michael Shrimpton will present that to you. Don't.
Thank you for taking over my job. We've had a tremendous afternoon. There's no time left for any more.
One quick comment, Harry.
No comments from me. I will have my say, and you will all shut up and listen.
Yeah, well done.
We've had a tremendous afternoon. I've given every single one a chance more than once. You've all had your fill, and I think we owe a tremendous debt of gratitude to John, who's answered every question, has produced information almost out of the air on subjects which he was not discussing, way above and outside the Constitution.
Right.
So I think we should owe him a great deal of thanks for what he's done today. Once again, thank you very much, John. It's been a wonderful afternoon.